Election Commission, July 6, 2021, 8 o'clock a.m. Thank you all for being here. We've got a fairly busy schedule or full schedule today, so we'll try to get through it as quickly as we can. Welcome back to everyone from the July 4th holidays. I'd like to move item 8 up since it involves our attorneys. Maybe we can get a brief report from them, and then they can get on their way. So item 8, status of and action on needs from litigation. Can we hear a report from our counsel on that? Oh, I'm sorry. All right, tell you what, then why don't we take up the minutes from the... Up, here he comes. Okay, no, he's back. We've called item 8 up first, Professor Blumstein, and could you give us a report on the status of the litigation, please?
I'm sorry, I didn't.
No, that's fine.
I thought we were down the agenda.
No,
Mr. Chairman, you want to give him a chance to get it set together?
are you ready to go, or we can do something else first?
Ready as I'm going to be.
All right, thank you.
And I'm sorry, nature was calling. You don't need to put that in the minutes. Like to say hi to everybody. Hope you all had a good 4th and stayed safe. And welcome, Mr. Davis. Nice to see Commissioner Davis. Nice to see you. And all the commissioners. I've said hi to them before. The commission met on June the 25th, Friday, in response to the Chancellor's decision on the case on the 22nd. Commission authorized appeal. I'm here to say what we've done, what's happened since that time, since that Friday. 25th, thank you, many of you remember, was our anniversary, so thank you for asking about that, and that was a big one, 50th. You can do the arithmetic. Mr. McMullen and I filed 2 documents on that next Tuesday, on the 29th. One is a motion to expedite the appeal to get faster treatment in the Court of Appeals. And then, as we promised, we filed a motion with the Supreme Court to assume jurisdiction, what is typically called a reach-down motion, for the Supreme Court to reach down and assume jurisdiction and, in a sense, pull the case up to the Supreme Court to give it greater expedited treatment under the circumstances. We filed that on Tuesday the 29th. On Wednesday the 30th, the Supreme Court ordered Metro Legal to file a response to the reach-down motion. And tomorrow is the deadline for Metro to respond to that reach-down motion. We don't know when we'll hear. This is totally up to the court and its discretion, but I think it'll be a matter of days. It could be Friday, it could be next Monday, but I don't want to promise that. But we don't know when exactly. But it'll be sometime soon. We'll know if the Supreme Court will agree to hear the case, to reach down and take the case. If it decides not to reach down and hear the case, then the case will proceed along through the Court of Appeals. We have this motion to expedite. We have filed what we have to file for that. We're going to get the record transferred up there. In fact, Mr. McMullen and I have on our list of things to do right after this meeting is to kind of move that process along and get that done in the next day or 2. So that's, Mr. Chairman, and members of the commission, that's kind of the update on where things are. So we don't have anything to report. We'll know Wednesday whether Metro is going to oppose the reach-down motion or not, and if so, on what grounds, or whether they'll agree that some form of expedited hearing is appropriate. In the Chancery Court, we did not oppose Metro's motion for expedited treatment. We thought there was legitimate concern, and we agreed upon that. We don't know what Metro's position is going to be. Whatever it is, we'll have to, respond accordingly. But that's where things are right now.
Do any of the commissioners have questions? Yes, sir.
Okay, when you appealed it to the appellate court, we have to wait till the decision if the Supreme Court is going to reach down to get it?
That's a great question, Commissioner Starling. Under the rules, the reach down motion does not slow down things or stay things or anything. That's technically. But also, there are no guidelines on when the Court of Appeals has to rule. And since the Supreme Court was immediate in its order to Metro to respond, we're all human beings in the implementation of our duties, and it may very well be, and now this is speculation on my part, it may well be that the Court of Appeals is waiting to see whether the Supreme Court reaches down. Even though there's no staying of the process, they may, since it's so rapid, they may be waiting to see what happens rather than spin their wheels. We don't know that, but technically the Court of Appeals could act, but since things at the Supreme Court are moving so quickly, they may have just decided to hold off for a few extra days.
Well, I guess, Mr. Chairman, it's somewhat confusing because if we're sitting here preparing for an election, we're sitting down here waiting who's going to move first.
Yeah, well, the ball, I'll use the word presumptively, but the ball is in the court of Appeals unless and until the Supreme Court decides to reach down. And so the Court of Appeals is technically where the action is unless the Supreme Court reaches down. But the Supreme Court has put the reach down process on an accelerated basis. And so Metro is going to respond tomorrow, and we'll know a little bit more what happens there. So it's on a very accelerated process either way.
Okay, so when Metro responds tomorrow, does that make the process any longer or shorter? Or,
once Metro responds tomorrow, then it'll be ripe for the Supreme Court to decide, based upon Metro's response and our motion, whether the Supreme Court wants to get into this early, which will be the only time that they can get into it before the proposed election. So I wish I had a better answer, Commissioner Starling, for you about the specifics, but until Metro responds tomorrow and then the Supreme Court decides, which I think will be in a matter of days, we won't really know. We can push the Court of Appeals to set an expedited schedule. We've asked them to do that, but it's just a question of days. And, it's hard for us to say with the holiday intervening and so forth that somehow they're dragging their feet. I would never want to say that under the circumstances. It's a very, very accelerated process. And so we may hear from the Court of Appeals this week as well, but my guess is that they're going to just wait to see what the Supreme Court does.
And one last question, not being a lawyer. If the Court of Appeals make a decision and said Metro appeals that, would the Supreme Court be heard then?
That's a great question. If the Supreme Court does not reach down, if that's your question, and the case then proceeds through the Court of Appeals, right? We have asked that the Court of Appeals render a decision in time for the Commission staff to conduct the election on September the 21st. And we've set out the timetable when military ballots have to go and overseas ballots have to go out. We've informed the Court of Appeals that the coordinated election has authority but is not required to, and Jeff and I had this conversation, we can't represent that the coordinator will do anything, but we can say that we would ask for an extension to allow us a little more, allow the court a little more time, whichever court it is, a little more time. And then the court would make a decision, hopefully in time, either A or nay, but if it's A, to allow the commission staff to get ready for this election on September 21st. And then, of course, we don't know what the outcome of the election is. These proposals may all go down. Some of them may go down. Some may be approved. And if the election goes forward, the Supreme Court, it would really be too late for the Supreme Court to decide. Now, if the Court of Appeals does not reverse the chancellor, then it would be possible for the commission to seek review. But in candor, that's a very tight timetable.
I just have a question about the motion for all the expedited review stuff. That's in light of the fact that we've set a conditional election for September 21st. Is that right?
Yes.
Okay, but we didn't have to set an election at that point, did we? I mean, there wasn't anything in the statute, and the Chancery Court had essentially said that there didn't need to be an election. So to me, it looks like we've set an election in order to push an arbitrary deadline so we can ask for expedited review on the Court of Appeals and the Supreme Court.
Well, Commissioner, I wouldn't say it's arbitrary, but I also agree it's not mandated. Here's what drove our recommendation, and here's what I think drove. I mean, I don't want to put words in anyone's mouth, so
Sure.
Let me just say what I think is going on. We have both a back-end timetable and a front-end timetable if there's an election, right? The front end are things like military ballots and getting ready for the preparation. And Director Roberts is the expert on that, and we have in the papers a declaration of his of what procedures have to go forward and what time that would take, okay? And then we have what we're calling back-end procedures. That is, if there's an election and if the election is positive on some or all of the proposed amendments, okay, then the staff needs time to certify. What drove the 21st is that one of the proposed amendments, the one involving tax rates, in the proposal is a desire to have effect for fiscal 21-22. And in order to have effect for fiscal 21-22, the decision has to be before the taxes are due. Taxes are due on the first Monday of October, which this year is October the 4th. As a practical matter, that means having the certification ready to go and in place on that previous Friday, which is October the 1st. So that's what drove the September 21st deadline, is that we thought that a September 21st would allow staff, if that particular proposed amendment were approved, to get certified in time to be effective for fiscal 21-22.
Thank you.
Any other questions? In order to fully inform the commission, do you have a suggestion about when we should set another meeting if we wanted to get an update on its status?
Mr. Chair, I would like to answer that, yes, but I really don't know. We have lots of balls in the air, and then ultimately it's the courts that control their own decision-making. We can request a timetable from them, and we have in our filings, and I believe we've shared that with all members of the commission. I want to be sure that everyone on the commission has gotten those filings. So I can't. What I would do is recommend that the commission stay fluid, but until we know what the lay of the land is, whether we're going to be in the Court of Appeals or whether we're going to be in the Supreme Court, we don't know. And if we're in the Supreme Court, We don't know, in the past, I'm told that the Supreme Court, when it's reached down, is sometimes just says, we'll look at the record and no more briefing. We would advocate that there be another round of briefing, although that's a lot more work on our part, but it's, we think, important. We've set out in our papers the issues that we think the court needs to address, and there are some issues, if they rule a certain way, they'll have to address as well. I think until we know more about which court it's going to be, what the timetable is, that we're kind of whistling in the dark here about what commission action. So I would just say stay as flexible as you can, recognize that there may have to be a meeting, but I can certainly keep the members of the commission informed through email and other. Mr. McMullen and I can keep the commission informed about what the status of these reach-down motion is and the motion to expedite is without a commission meeting. I don't see a need for a commission meeting right at that point. Plus, I don't really have any more information. Once we hear from the courts, then that would be time to consider that action. I'm sorry I can't be more specific, but that's just the reality.
Thank you. Okay. Anything further from the commissions from the commissioners for our lawyers? Okay. All right. You're free to go. Thank you. Yes. Yes.
Okay. Thank you all. Thank you. We'll keep everyone informed.
Okay. That will bring us back, I think, to item 1, which are the minutes from the June 25th, 2021 meeting.
I noticed one typo.
Uh-huh.
I'm sorry that I didn't catch it before. In my motion to have the emails and letters attached to the official record, it just says letters and emails from various council members, and I think it's supposed to be council members and the public.
I apologize. I did not receive these minutes until Sunday evening, and I didn't receive the agenda or the notice of the meeting either. I think they were being sent to another email address instead of my personal email address. But I do have a suggestion, and that is under the status of litigation and necessary action, after the first sentence about Commissioner Hertzfeld expressed concern that she did not receive the resolution prior to the meeting. I suggest that we add the statement, none of the commissioners received a copy of it prior to that meeting, because I think that is the case, and I believe that was mentioned at the time. So that's my sole suggestion. We've had 2 suggested changes. Is there any discussion about those 2 suggested changes or the minutes themselves? Okay. With that, is there a motion?
Motion to approve the minutes from June 25th, 2021.
Okay. With the suggestions?
With the suggestion of changes.
All right. Okay.
Both,
All right.
In the of Commissioner Hertzfeld as well as the litigation status.
All right. Okay. Is there a second?
Second.
We have a motion and a second. All in favor say aye.
Aye.
Any opposition? With no opposition, the motion carries. We have, as item 2, the third item on our agenda that we're taking up anyway is numbered 2, approved compensation for machine technicians. That's really a matter where we need a report from the staff. Mr. Roberts, can you inform us about that?
Per the state statute, both the Republican commissioners and the Democratic commissioners are to approve their machine technician's salary. The salary that increase that's proposed by Metro, for all Metro employees, we're applying that same salary increase to the machine technicians.
Okay. And for the public, anyone who's listening, can you explain to us who the machine technicians are and, why they're designated for one of the 2 political parties, et cetera? Can you just give us a brief
Sure.
explanation of that?
We have both a Republican and a Democrat machine technician. The purpose of that is to make sure we have a check and balance of everything we do from a machine standpoint. So they are reviewing each other when we prepare the machines, when we audit the machines, all of those type things to make sure we're offering or performing fair and equitable elections here in Davidson County per the state statute. Mr. Medley is the Democrat representative and Mr. Green is the Republican representative.
And they take care of the voting machines?
They take care of the voting machines, right.
All right. Okay. All right.
We just need a motion from the Republicans for Mr. Green and the Democrats for Mr. Medley. Each one has to be done separately.
I'll make a motion for Bobby's rate.
Okay. Any discussion? All right. We have a motion and a second. All in favor say aye. Aye. Any opposition? With no opposition, the motion carries. Do we have a corresponding motion?
I make a motion for Mr. Green.
All right. Okay. We have a motion. Do we have a second? Second. All right. We have a motion and a second. All in favor say aye. Aye. Any opposition? With no opposition, the motion carries. All right. We also have an item on the agenda. Numbered 3 on our agenda is to approve the compensation for the administrator of elections. As I understand it, that's a step raise along with everyone else, but since it's our AOE, the commission has to approve it. Has to consider it. We don't have to approve it, but we have to consider it.
But I think what you need, it's not truly a step raise. My salary's based on state statute.
Right.
It's linked directly to the tax assessor here in Davidson County, just like the salary. My counterparts in every other county, their salaries are linked to the tax assessor in that county. Those calculations come from the state and they are given to Davidson County. So it's more of a, I guess, a set thing
Okay.
going forward.
Okay.
Or that's the way it's been in the past. So
All right.
it's probably a good decision that we stick with that percentage of the tax assessors.
Okay. Do the commissioners have any questions?
I think there was a discussion about deferring this before. Are we not deferring?
I think the salary itself, I would go ahead and do it. That's just a standard,
Okay.
policy per the state's provided that information to Metro at this point. So I think that would be
It's
easy.
the standard state rate.
Standard state rates.
Yeah.
Right.
Got it. Okay, I'll make a motion to approve. Sorry.
No, you're fine.
Okay, we have a motion. We have a motion and we have a second. All in favor, say aye. Aye. Any opposition? With no opposition, the motion carries.
Thank you.
Number 4 on the agenda is to consider the early voting schedule and locations for the potential September 21 referendum. I think we should have something in our packets about that.
Included in the packet, our standard early voting schedule. Please note on there that we do have, we'll be crossing Labor Day, so we have to notice that Labor Day is, we will be closed for Labor Day, assuming September 21st election. And those dates are based on state statute also.
I have a concern that we perhaps are confusing the public by putting out early voting dates for an election that's been considered conditional at this point. When is the last date that we would have to approve the poll officials and their early voting locations for September 21st election? Just feels a tad bit premature right now.
The poll officials, we can do them 90 days before. So we're within that schedule now. And it's really the training for the poll officials. We can do that up to like a week ahead of time. But we like to at least be able to send out the notice to give the poll officials a heads up, that we have a potential for that, and we really can't send out that notice until you approve us notifying them. So that's the reason we're recommending that we go ahead and do it. We don't have to post the schedule until we actually hear something. That would be our standard practice, that we wouldn't confuse the public. We wouldn't put it on our website or any of those kind of things until we know for sure that we're having an election.
And I think my concern is that I've heard from a couple different poll workers who at this point are confused, and members of the public, about whether this referendum election is going to happen or it's not going to happen. So considering it's a conditional election that we've set that doesn't have to be set by that date, it's a date, as Professor Blumstein said, that was chosen by us in order to effectuate some particular position within the referendum. I'm going to be voting against doing anything in preparation of that election. So you all can do as you wish.
Mr. Roberts, you said 90 days, I think, before September 21st. Does that make it basically the last day we could do this is July 21st?
That's the first day we can do it.
Okay.
We can, in fact, that it used to be 60. We asked the legislature to give us more time because we're dealing with such a large number, training that many people. Really is our biggest challenge. So the sooner we can notify them and get them trained, I think at this point in time, since we are planning to use the same training materials that we had for November, we're going to do online training. We've got a little more flexibility there. We don't we don't have to bring people here into the office. That scheduling was really problematic if we didn't use that full time frame. So I think that's why I'm saying that we want to be able to notify the poll officials to keep this date out there, and that they have been identified as a poll official for this potential election, but we don't look to be doing anything until we hear from the court.
If we approve this proposed potential schedule today, will that trigger any substantial financial expense?
No. Again, we're not looking to do anything in a big way until we know for sure that we're having an election on the 21st. This just puts us in a good position that should the commission, we don't have to come back and have a commission meeting just to set the early voting schedule, or just to do the poll officials. It gives us a little more flexibility. And I understand, what Commissioner Hirschfeld's, her point that we don't want to confuse the public or and we can inform the commission when and if we're getting ready to put information out in a public way. This would just be internally, it allows us to prepare.
Any other questions?
So we're just really notifying them, but we're not publishing any of these dates.
Correct. Right.
And, I sort of understand what Commissioner Hirschfeld is saying about the confusion. I get that.
Right.
But I am for us being prepared. I don't
Right.
want us to be caught flat-footed
Right.
with anything, so. yeah.
I think that's our goal also, because that level of confusion is a big potential that we need to avoid.
If there's no further questions or comments, is there a motion?
I make the motion to approve the
Do we have a second?
I would say.
Yes, sir. We have a motion and a second. All in favor say aye.
Aye.
Any opposition?
Yes.
All right. We have Commissioners Starling, Davis, Evans, Delanus, yes, and Commissioner Hertzfeld, no. Next on the agenda is to approve poll officials for the September 21st referendum. Mr. Roberts, could you explain the process on that item on the agenda, which is?
We would ask that the motion identify all active poll officials to be included in this cohort to participate. And that's what we would do, is say that you've been identified as available to participate. And that would be the extent of it, because we can do it by email. So it's a quick, hold this date. We're not advertising any kind of training or telling them where or anything like that. It's just, you've been identified, hold this date, and we will get back in touch with you.
Yes, sir.
Now, on that, I did have some concern, because I'm a little concerned that, are we gonna lose workers? Because we're shifting the date. One time we had it one time, this time we're having another. People take vacations.
Correct.
And, I mean, it could, we could get another ruling and it could change again, and I understand that, but I'm just, are we losing people? Are we losing anybody because of?
At this point, we
Yeah.
don't know for sure if we're losing people. I mean, because of the window when this is happening and the age of our poll officials, you
Yeah.
think about it, it's a great time for vacation if you're over 65, because no school kids will be anywhere. That, we risk that. Our goal here by doing this is to try to keep our poll officials informed. If you're interested, you may want to keep this date, put it on your calendar. It's not a guarantee that we're gonna have anything, but we just wanna keep you informed. That's one of the things that we've heard from poll officials in the past, that keeping them informed on what might happen, when it's gonna, all those kind of things is very important to them.
Yeah, and I was just, wanted to make sure we had enough personnel when whatever date we
Sure.
decide to have the election, because, when you start moving it every
Right.
which way, and I'm saying this because I also heard from a poll worker said, hey, listen, I held my vacation off because we heard it was gonna be July, now September.
Right.
And I just wanna make sure that when we recruit enough folk, because
Right.
with this shifting,
Right.
we could be caught short-handed.
And one of the reasons that we
Yeah.
ask you to approve all of the active is that we can go out and capture folks that I had a vacation scheduled on the 27th, I couldn't participate. Now, the 21st, that's available for me.
Yeah.
So when we go out and reach all of those people, and we have a much larger pool of potential poll officials than we've had in the past. So it gives us more flexibility to work with them, what works for their schedule,
Yeah.
those kind of things.
Yeah, and I'm just concerned because I know, John works hard at trying to recruit people, and then if you get a flux of folks say, I'm tired of fooling with the election commission because they're all over the place.
Right.
And, that's,
So simple communication at this point
Yeah.
is what we're looking for, because otherwise, the phone calls that you're not getting,
Yeah.
they're coming here to us to
Sure.
say, what's going on, I don't understand, is there going to be an election or not? All of those kind of things we're
Yeah.
getting anyway. So this allows us to kind of put in motion a soft date they can understand.
So will this be
Prepare
on
for.
you'll just communicate that?
We communicate directly with the poll
With the
official.
poll officials, okay.
Mhm.
So it won't be anything on the website? Okay.
No. No. The best thing right now to keep the public from being confused is that we do not get aggressive on public notification. We wait until we know something, and then we can go forward at that point in time.
Well, it is confusing.
Yes,
It-
right.
It's confusing to me as a commissioner,
Right.
so, yeah.
Are there any other questions or comments? With that, do we have a motion?
I'll make the motion for Ailey Roberts to send out those communications for email for poll workers.
Is there a second?
I'll second.
Okay.
I have those concerns, but I'll second. Just for the purpose of making sure that we are not caught flat-footed, like I said on the first one. So,
And I think
that's,
it might make sense that before we send it out,
yeah,
we notify you guys that the communication's going out. So if you do hear from poll officials, you can speak to exactly what we've sent out.
Sure.
So that you can help us tone down if there's some confusion, you can do some help there.
sure.
Okay. All right. We have a motion and we have a second. All in favor, say aye. Aye. Any opposition?
No.
We have, the motion carries with Commissioners Starling, Davis, Evans, and Delantis, yes, and Commissioner Hertzfeld, no. That brings us to item 6, schedule locking of provisional bags, boxes, and absentee bins. Mr. Roberts, can you just explain to the commissioners and to anyone who's observing this what that's all about?
So for both provisional bags, all of our absentee boxes and bins, those require a Republican and Democratic commissioner to actually lock those bags and bins. And you're placing also a numbered seal on there that we have to provide to the state. This makes sure that none of those have been opened prior to the election. And if you look at that date, that's we're recommending August the 3rd at 8 a.m. August the 7th is when the military ballots would go out. So we're trying to pick kind of that latest date that we take these actions, and hoping to know by then whether or not we're having an election. So that's why that date, we're recommending that date. It's to coincide with when the military ballots could potentially go out, or would be required to go out.
What was it, August 3rd at what time?
8 o'clock.
So I'll make a motion to approve August 3rd, 8 a.m. ballot block.
Is it, Commissioner Starling, is
Second.
that's all right with your
That's great,
schedule?
that's fine. Mhm.
Okay, all right. Any discussion? Seeing there's no discussion and that we have a motion and a second, all in favor say aye. Aye. Any opposition?
No?
The motion carries with Commissioners Starling, Davis, Evans, and Delannis saying yes, and Commissioner Hertzfeld voting no. That brings us to a report on open meeting protocols.
So included in your packet is some information that we received from the state at the Open Records and from the Open Records and Meeting Council, Lee Pope. It gives us, really fine-tunes the guidelines to make sure we are acting in a legal manner as far as open meetings. And now that we know this is the point, folks, we can go back to them with questions about more questions on open meetings or open records also. So that's in your packet just to provide that level of information. No questions arose in the last meeting about it, so this was an attempt to get some direction from the state on that.
Okay. Are there any questions for Commissioner Roberts about that? And thank you for doing that, because you know, very deep in the back of my mind, I knew there was an Open Records Act at the state, but an Open Records Council at the state, but I just didn't remember it at the last meeting. So, and that's a really valuable resource for us to have.
Is this communication privileged?
This, no, I would think that's a public document that you know, we could share with anyone, because it's important, I think, for the public to know, here's why we're doing things. It's to make sure that we stay within the law as far as open meetings and open records. And not to say that we haven't been, but just to put it out there, one more tool in the toolbox.
Are you thinking incorporate this in the minutes?
That'd be fine.
Okay. I prepared some potential guidelines really based upon this guidance we got from the Open Records Council, and I'd like to pass it around just for people to look at. I'm not really going to call it up for a vote or anything like that. It's just for us to think about whether we want some guidelines or we don't want guidelines. But since we got this advice, I thought perhaps it would be something to think about for future meetings. And I've got a copy of the guidance we received from the Open Records Council attached to it. Just,
Oh, you got enough for everybody?
Yeah, I
Oh,
made a
okay.
couple copies.
Oh, okay.
So, okay. If there's nothing further on that, yes, ma'am.
I believe the advice from this document that we've received from the state would conflict with the vote that this body took last meeting, would it not?
I don't think so.
So you're standing
didn't-
by the vote last meeting to ensure that our council was not keeping me informed the same as the chair?
I don't think the vote conflicted. How would it conflict with the guidance we received?
I believe there was quite a communication about whether or not they could reach out directly to each commissioner. I believe you said that was the basis for your vote, believing that they could not reach out to each commissioner. And I think it's very clear here that council can communicate with each commissioner on this body. And if you'd like to stand by your vote, then that's
Well, yeah,
fine.
I mean, we talked at great length about how you wanted our lawyers, when they called, when I spoke to them, you wanted them to immediately call you. So we got into a discussion about whether or not the lawyers could tell you what was said to me, and that raised all these open meeting concerns. So that's what caused the contact with the, among the things that caused the contact with the open records folks. And I don't believe that our vote conflicted with that. I don't believe our vote said you couldn't call the lawyers up. And that's certainly what we can do and should do. That's what I do. So no, I don't think our vote conflicted with anything that the Open Records Council told us.
I think that's quite a bit of revisionist history, but I appreciate the fact that you're doubling down on your position. I don't have anything else.
Okay. That brings us to the AOE report. Commissioner Roberts, is there anything further to report?
No, I think staff are kind of sitting on go, waiting to someone to tell us that we need to make additional preparations for September 21. At this point in time, we're not doing any additional preparations because we still have everything left over from July the 27th.
Okay. We've got, I think we need to go back to the status of an action on needs from litigation. Mr. Odebiku is here, and he has reported to us previously about the first case, the one that we had that is still active. Welcome. Thank you. Appreciate your being here. There's been a development in the case. Now, the last time we spoke to Mr. Odebiku, and this again, this is on the first case, not the case that's before this, that is has been appealed, but this is the case that remains in front of Chancellor Lyle. And there's been a slight development, and I thought it would be best if June 8 come back to us just to make sure that the Commission's instructions to him and me remain the same. So if you could, with that, kind of give us an update on what has happened since you were before us the last time, and thank you for being here. Good morning.
Thanks for having me. I guess the 30,000 foot level update is that since I last was here, we had a hearing on our motion for judgment on the pleadings, which was a dispositive motion to get rid of all the remaining claims in the case. We were successful on that hearing. The judge ruled in our favor. We are still tidying up the written order that would be entered to have a final order to get rid of it. I'm expecting that any day now, actually. The additional development, so that's good news in terms of getting rid of the case. Of course, For Good Government could always appeal that, but the basis of the order was that For Good Government conceded that they were missing one of the essential elements of their claim. So I think we would have a strong argument on appeal, and I think that would dissuade them from making an appeal. The reason why we haven't gotten the final order yet is there were two grounds that we won on. One was that they didn't have an essential element. The second ground was an argument we had made in our briefing, which was that Section 1983, the civil rights action claim that they filed against the commission, we argued that that didn't apply to the election commission. and Chancellor Lyle has taken that issue under advisement, and that's what we're waiting to hear from. So one way or the other, we have prevailed in the case. It's just a matter of, are we going to prevail on one of two issues, or are we going to prevail two times? So that's a good development. The new development that the chair speaks of is a settlement offer for good government. And if you allow me, the timing, I'll explain a little bit the timing of the settlement offer. We made an original offer to For Good Government back in April. It was April 19th, I believe. That offer was for them to dismiss their claims in exchange for the commission not seeking discretionary costs against them for the lawsuit that we prevailed on in the fall, which amounts to about $6,000 or so. For Good Government countered that offer a few days later on April 25th by saying that they would only agree to settle the case if the Election Commission and Metro agreed to drop all claims to fees. So kind of standard black letter law is when you make a counter of an original offer, you've rejected the original offer. Nevertheless, as you all know, we proceeded forward with litigating the dispositive motion. On June 9th, we had that hearing. Chancellor Lyle gave her oral ruling in our favor. And then on June 16th, Jim Roberts, on behalf of For Good Government, reached out to me by letter and attempted to accept the original settlement offer that I'd made back in April. I didn't respond to that letter. I was out of town, actually, so I didn't respond to that letter until Monday. I told him that I didn't consider that the matter was resolved, but that the Election Commission would have to take the issue up. I think he sent me subsequent correspondence asking if the case was settled. I responded again that, you know, the commission will have to take it up. There was an offer, and then you made a counter offer, so we never had a deal. And then late last week, For Good Government filed a motion to compel compliance with our settlement agreement. You may ask yourself, what agreement? But their argument is that the court should compel us to accept our original, the court should compel our original offer on all of the parties. Typically, for a motion to compel settlement to be successful, you need to have an actual executed agreement with, you know, stated terms and so forth. That's not the case here. They're asking us, the court, to compel an offer that they rejected. Nevertheless, they filed a motion, and that motion is set for hearing on July 16th. So the issue before the commission now is we discussed resolving the case by settlement last time I was before you. We have a favorable judgment in the case, favorable oral judgment. I'm expecting the written order any day now, but we also have a settlement offer that has been made. I think it's a little complicated because I don't, as things stand right now, determining what we're settling is difficult because of the status of the dispositive motion. Nevertheless, there could be potential for an appeal, and maybe we would settle the appeal, but that's where things kind of stand currently. I think what's really at issue here is just whether or not the commission wants to resolve the issue involving the $6,000 or so in discretionary costs that For Good Government would owe the commission, and how we choose to handle that. I think that's really what the proposed settlement is about. So that's, and that might have been somewhat convoluted. I'm happy to answer any questions that anybody has.
So Mr. Roberts could still appeal an adverse decision, and that would lead to more legal costs. So we have that on one side. Do you have a sense that he is willing to sign a full release so that this would be over with so far as the commission is concerned? if we go forward with settlement?
I think he would sign a full release. He's indicated that to me. Now, that his request has always been that Metro and the Election Commission release his claims. I obviously can't speak for Metro. They've been reluctant to do so. They have a written order, so their case is completely disposed of. I think the question before you really is, with respect to an appeal, it's whether or not Chancellor Lyle will grant us relief on the claim that the civil rights law doesn't apply to the Election Commission. If she denies that, then the whatever appeal might happen would be incredibly weak and almost, with respect to for good government conceded in the trial court that we were right. So it'd be difficult for them to appeal an issue that they conceded. In fact, they would have waived any argument on it. So yes, we could, if Chancellor Lyle grants our alternative grounds that 1983 doesn't apply to Election Commission, that could lead to additional litigation, but I don't have a sense for whether or not she's actually going to grant that. And if she doesn't grant it, then I think that the likelihood of additional litigation would be minimal.
Does anybody have questions? I mean, I have a suggestion. This is a suggestion, not a motion, but it could be converted into a motion. Just request that our attorney proceed with attempting to settle it so long as we get a full release from the other side.
I actually think we should go after the costs.
The $6,000 on the one side and the cost of an appeal on the other side.
I think what he said was the likelihood of an appeal seems to be pretty slim, and I'm pretty sure we could settle it if it looks like there's going to be an appeal at some point. I mean, at this point, it's cost the taxpayers quite a lot of money in attorney's fees and otherwise, this litigation. So, typically I'm for waiving costs, but in this case, there's a first lawsuit, there's a second lawsuit. I'm sure there'll be a third petition and a third lawsuit, or a fourth and a fourth. And at some point, I think you have to go after the costs that have been incurred. So that's my position.
What would be the potential cost if the other side did appeal? Are we talking about, I mean, in the range of how much would an appeal cost us?
Well, let me say this. An option that the commission has is we could always drop our argument that 1983 applies to the commission. If we drop that argument, then that would functionally get rid of the appeal. So the commission could always do that. The cost of a full-blown appeal, if the only issue that we are taking up is the essential element issue, I think that would, I can't imagine that I would envision that we would just file a motion to dismiss that, which would just take a few hours of lawyer time, again, based on the fact that they conceded it at the trial court. If we fight the 1983 action, then you're looking at more of a regular appeal, which, cost range, but that could then get you into the tens of thousands if we were to fight that all the way, which that's be a decision for the commission to make.
And in order to collect a judgment for this $6,000, what would that entail?
Filing a motion for discretionary costs. The rules of civil procedure permit the prevailing party in a trial, which we had back in November, to be reimbursed or to collect this discretionary costs. Those are costs for court reporter fees, copies, different things like that. The rules allow for the prevailing party, which is the Election Commission, to file a motion. That motion is a fairly simple motion. It would take a couple hours to draft, and then you set it for hearing and maybe an hour hearing. So I think you're looking at 5 hours or so of lawyer time to try to pursue that.
And then you would have to try to collect that money, right?
Right.
And who do you know who you would collect it from?
Well, that would get into issues of post-judgment discovery. So
Right.
if depending on how hard For Good Government wanted to fight us on the collection of it, then you have to send them interrogatories, perhaps discovery like that. They are a known entity. We don't know. We know who represents them. We could have conversations with Mr. Roberts, but if they chose to fight it, then it might be a little more difficult for us to collect. It's hard for me to know exactly how much
Right,
how much
right.
time it might take. It depends on how cooperative they were.
So you don't know whether we would even collect the money, and you don't know how much time it would take to do that, and we would not be compensated. I mean, that would just be more money that this commission would pay to pursue this. Would that be fair to say?
Yeah, that's possible. Yeah.
Okay, all right.
So the first initial agreement, proposal was to settle it and not for Good Government to have to pay anything. Is that right? And they refused that.
That's correct.
Okay, so when they refused it, we're right back where we are now.
Yeah. Yeah, the first proposal was you dismiss your claims and everyone walks away. Or, let me be precise. My proposal For Good Government was you dismiss your claims against the Election Commission and the Election Commission will walk away. We will not pursue our discretionary calls. We won't pursue any additional attorney's fees that we might be entitled to, arguably. Their response was, I don't feel like we can dismiss all of our claims, and even if we could dismiss our claims, I will only dismiss all of them if the Election Commission and Metro agrees to walk away.
That's no way we can determine what Metro is going to do, right?
Correct. The indications I've received from Metro is that, let me take a step back. Metro has not settled the case with For Good Government, obviously, and it's my understanding that Metro is interested in seeking its cost.
But essentially,
Good Government people have agreed to the terms that we originally set forth, and they're willing to give us a release today. The only question is, do we, instead of doing that, getting a release, do we pursue this $6,000, and do we continue to pay our lawyers to do that?
And I guess I'm confused, and it seems like to me it's all inclusive, regardless of what we do.
No.
Metro is still in there. It's got to be, Metro's got to agree as well.
No.
That is what For Good Government wanted, but that doesn't, the way things stand now, Metro also filed a dispositive motion at the same time we did.
Mm-hmm.
Chancellor Lau granted Metro's motion too. Metro has prepared an order dismissing For Good Government's claims against Metro, and Chancellor Lau has signed that order. So the trial court proceedings are basically over with respect to Metro. For Good Government could appeal Metro's order, but I think it's unlikely that they would because, again, they were wanting to settle it at the trial court level.
But we can settle separately from Metro, and then we're out of it. Then we get a release, it's over with. We're done. We don't have to pay lawyers anymore. The only thing we give up is the right to try to pursue this $6,000. And if I hear counsel correctly, we don't know if we will ever collect that, and we'll have to go through considerable work even to get to that point. So, I mean, that's essentially, so, I mean, we're not really very far from where we were the last time we considered this, but in an abundance of caution, since there's been a few developments, I thought we'd better talk about it again.
I will say, as an addition, if I may, if for some reason Chancellor Lau were to rule in our favor on the issue that 1983 doesn't apply to the Election Commission, that's potentially a good ruling for the commission to have in the Davidson County Chancery Court. So a potentially preclusive ruling on that issue that might ward off future lawsuits is also something that we may be giving up. I don't know that she will rule in our favor on that, but it's to have all the issues on the table.
Any further discussion, comment, questions?
I do. I guess I want him to review the options on the table one more time.
Okay.
So would you please review our options, as they would say if you're asking for a ruling?
Yes, absolutely. Option one, I would say, is we could settle today being as soon as we can make contact with For Good Government, in advance of Chancellor Lyle's ruling and get a full release. Option two is we could wait for Chancellor Lyle's ruling, which I think is coming any day now, and see the scope of her ruling and make a determination on do we sell, if she only grants us the first part of our request, which is that they lacked an essential element of their claim, which they conceded. If we wait for her ruling and she only gives us that, then we could that ruling essentially, let me take a step back. If she gives us that ruling, we could take that ruling and the commission could decide that it either wants to accept fees or not, or wants to pursue fees or not pursue fees, but it has the option to do either. And then also, if we wait for Chancellor Lyle's ruling and she gives us relief on both counts, we could still settle the case with For Good Government if they indicate they want to appeal the 1983 ruling. So option one, settle today in advance of the ruling. Option two, wait to see if we get a good ruling, and if we get a good ruling that For Good Government doesn't want to appeal, we live with the ruling. If they want to appeal the ruling, we could settle at that point.
And just for clarity, if we were to go after fees, you said, and don't let me put words in your mouth, I'm asking just
Sure.
to see the whole 30,000-foot view.
Absolutely.
If we were to go after fees, you suggest that it may cost up into tens of thousands of dollars?
No. Well, tens of thousands of dollars to pursue fees seems like a lot. I think this is work that a more junior attorney could do. It's sending a standard set of discovery to For Good Government, which we have done in other cases, and then finding, just like collecting any judgment, you find any assets that you can attach through the county registers, through any kind of public searches. If they have assets, you attach them. If they don't, then you can't. So that's just a few hours of junior lawyer work.
Yeah, because I'm just trying to see what the cost-benefit analysis
I
is
think
here.
that the tens of thousands of dollars would be a full-blown appeal on whether or not 1983, the Civil Rights Statute, applies to the Election Commission. There are off-ramps that we don't have to have a full-blown appeal of that. Chancellor Lyle might not grant us that relief. And then number two, the Election Commission might determine that it doesn't want to pursue that if it looks like you're going to have to spend $10,000 on an appeal. It might not be worth it to the commission to have that judgment in its favor if there's going to be an appeal of it.
The motion for costs is a pretty typical motion. You probably have a whole bunch sitting in a motion bank at your office, right?
Yeah, it would not take very long at all to adapt that to this case and attach our court reporter and cost bill invoices and have that.
And if we were to get, if we were to prevail on the motion for costs, it's an additional step and decision that we would make of whether we were going to do post-judgment discovery to try to track down money. I mean, that's like a separate decision we would make. It's not like if you just get a ruling that you get costs, then you therefore on the hook for going through all this post-judgment discovery to find assets. You can file the motion, the judge can say, yes, you are granted costs, if I understand you correctly, Mr. Tobacco. And then, right, you can then make a decision of how hard you're gonna go to try to find that money. Did I understand that correctly?
That is correct.
Okay.
I represent the commission. I take orders from the commission. At any point the commission wants to turn off the spigot, that's what I will do.
So, of course, if you file this motion, then you have to go over to the courthouse and argue the motion. Then the judge is going to turn to you and say, you draft the order, okay, and whatever the associate is doing on that, you're going to have to review. So then we wait 30 days when that when that order becomes final, and then somebody drafts some interrogatories, and they're going to have to be somewhat modified for the purposes of this case. Those are going to be prepared. You're going to review them. The other side's going to have 30 days to answer. They're probably going to ask for an extension of time. They're going to give you a response. Somebody's going to look at the response. They're going to say, hey, they didn't fully respond. Someone's going to file a motion to compel the court to require answers. You're going to look at the answers. Quite possibly somebody's going to want to take a deposition in aid of that collection process. And then we're going to find out if they have any assets. And at that point, you're going to have to issue process, get, maybe garnish something, put a lien on something, and that's if there's no appeal. And the most we can get is $6,000, and we don't know if they have any money. So I mean that's, and most of what's being done, you can reduce your involvement, but you're going to have to review it. And what rate is your rate, and what is the associate's rate? I
think for this engagement, our rate is my lowest discounted rate, which is like $400. Okay. I think associates, that rate is, in this case is, I think it's less than $3. I want to say it's. Okay. Quote me on this. I can get you the right number, but. Okay. It's in the 200s, I want to say.
All right. Okay. And then if there's a motion to compel, you have to draft that, and you have to go up to the courthouse and argue that. And then there's going to be an order. If you win that, the judge is going to turn to you and is going to say, Junaid, can you draft the order? And then it's going to be submitted to the judge, and then you're going to have to review her order when it comes out. So that, that, I mean, is that really 10 hours, or is that more like 20, 30, 40 hours?
I don't think it's
potentially.
20. I don't know if that was a question to me or not.
Right.
I mean,
the parade of horribles that you just put out there is exactly the entire post-discovery process that I discussed earlier. That you absolutely could just file the motion and be done. But obviously, you feel very strongly about this and exactly what needs to happen. So why don't we just take a vote so everybody can get to work
Everybody's
this morning.
talking about costs, and I just want us to have a realistic view.
Happy to do it. I'm happy to take a vote so we can all get to work.
Okay, I'm sorry. I didn't mean to belabor the point. I thought everybody was allowed to ask questions. Okay, is there a motion? Anybody have, or further discussion? I'm sorry if there's any further questions.
Okay, so we are trying to make a motion whether we go option 1, 2, or 3. Is that where we are?
Right. Yeah. Do we? I don't want to misstate, but we've got various options. Whether we just end this now or go through one of the other options that's been presented to us.
Well, I will make a motion that we take option number 2 and we wait on the decision from the judge.
I'll second.
All right. Any further discussion? Okay.
Let me ask just one question out of curiosity. If waiting for the judge, does that, from what I understand, if I'm wrong, please let me know, counsel, that if we were to wait, we're still in a position where we could still do anything that we would do right now in regards to option 1. Is that correct?
Yeah. I mean,
That's correct.
Yeah,
And-
we can always settle.
Right. And there's
can always settle.
and there's is there any additional cost in waiting? Is my next question.
I mean, other than we're going to have to continue to, there's always that cost of, do we get this off of our plates and get it over with?
Well, I guess substantial cost. I guess it'd be my, you know, if he has to be in court for an hour. I'm just trying to see where the fight is here.
Mr. Chair, if I may, if we, waiting is waiting. If the only thing, if we are waiting for the judge to rule, I don't have to go back to court for her to issue her ruling. She'll file it electronically, and I just have to read it. But I'm going to have to read it regardless to be able to advise the commission on the best thing to do. The commission could wait on the judge's ruling and then make a separate determination on whether or not it wants to pursue fees. The commission does not have to pursue fees. That's a decision for you all to make. I think that is the primary concern for good government at this point, is that it is a very unusual litigation tactic to try to settle a case after you've lost it. But it leads me to think that the biggest issue on the table is just potential cost and fees from their perspective.
And, okay. And you might have to come back and report to us again. And you're obviously charging us for your time here today, but also for your travel time down here today, right?
Is that a question?
I mean, it is.
Yeah,
I mean,
it's just
the commissioners may not realize that, but I know as a lawyer, typically, if we have to drive somewhere to attend a meeting, unless there's some special agreement otherwise, typically to and from time is charged to the client. And that's why we try to take up the lawyers right away so they don't sit around watching our meetings, as exciting as they are. So, I mean, I just, you know, we've been messing with this for a long time, and I just think we need to get rid of it. $6,000, we may never collect it. We may never see a dime, and Mr. Odabico may be up here again having to report to us about this. I thought we decided the last time, basically, that we wanted to settle this. It's the same $6,000. Yeah. I think Mr. Roberts made a mistake by not snapping up that proposal at the time. He should have. But here we are again, and we've got to make a decision. I don't think things have substantially changed, except for the fact that we've had to pay a lawyer for his time, and are we going to try to just send him a message that he shouldn't have done that, or are we going to try to save the commission's money and just put this behind us? So, I mean, that's kind of my thoughts on it. Reasonable people always differ on issues, and this is one of those. Of almost all the issues we have, reasonable people can differ about how we deal with these kinds of issues. So,
Mr. Chairman, I totally understand. I'm sorry.
Oh, I'm sorry. I didn't want to.
No, I was just saying, you know, we've been spending money on lawyers all
Right.
month. I mean, if we take that same concept, we a whole lot more than this was going to cost us. So, I mean, I'm looking at the other lawsuit, and I'm not trying to mix these all up. But you know, I just think that, you know, my opinion is I think we need to wait on the ruling of the judge, because either way we could settle on the $6,000 later. I'm just
perhaps.
Yeah,
He
perhaps.
He could appeal. And
absolutely.
I mean, he could appeal, and then you've heard about, you prepare the record, you know, you have oral argument, you prepare the briefs, etc., And you know, you can't. I mean, you can't just say, well, you know, this is not a strong case by the for good government people, so we're not going to prepare ourselves. Mr. Odebiko's got to do his good job, his normal, you know, good job on that, and that's, you know, that's expensive.
Well,
And
a
do
good
we,
lawyer costs
I
you
mean,
money.
do we have like do we have some big principle we're fighting for here that we want to pay these lawyers to pursue, or is it just 6,000? We got $6,000 is our big principle here, and I just wonder whether
We sort of operating on principle in a sense on the other lawsuit, so.
well, we are. There is
Yeah,
a
I
big
mean,
principle there.
Yeah, so.
There's a big principle
And there's
there.
a whole lot more money on that first lawsuit, on that other lawsuit.
But-
And I don't mean to mix them up.
Sure, I know, but we are. There is a big principle in the other case.
Yeah.
Here, I don't think $6,000 amounts to a big principle. It's $6,000. We're not. There's no big principle, I think, as there is
So we're
right.
putting the cost on principles?
I'm not putting a cost
No,
on
I'm
it.
just-
No, you're exactly right. There are big issues in this second case. In the first case, we got it down to $6,000. Are we gonna say we accept the fact that we've won, or are we gonna keep that case alive for $6,000? You know.
I'm sorry.
Go ahead. Yeah, I'm sorry.
Let me play the ultimate devil's advocate.
Mm-hmm.
What happens if we lose? In other words, we hold on. We say we'll wait till the judge. Judge rules in favor of for good government. Now, where does that put us?
We've already won.
Okay.
When we
But
had
the reason. Okay, I'm sorry. Please.
Oh, no, go ahead, finish your question.
No,
apologize.
I just wanted to understand. I understood that part, but you said that she might not. The 1983 ruling might not go in our favor.
Correct.
And so that's where I was trying to make
Yeah.
my question.
If the 1983 ruling goes against us, we've already won. We're trying to win. I always state this unartfully. We're trying to win on two grounds as opposed to one ground. If she does not give us the second ground, we already won on the first ground. So it really then isn't. I think it's unlikely that they appeal the first ground. It's more likely that they could appeal the second ground.
And that's where we get in trouble of more money.
Yes, if the commission determines that it wants to actually pursue that issue, then that could be more money spent there. But Mr. Chair, if I may, just for full disclosure, there is a process to settling a case too. And so a settlement agreement, we have not drafted any kind of settlement agreement. We'd have to draft a settlement agreement. For good government would have to review it, make sure they're okay with it. I think in principle they would be fine, but as y'all all know, devil's in the details sometimes. We want a full release, so devil's can be in the details. So there is additional time that has to be spent in terms of settling a case. And I feel like I have to say this, if it takes, a day or two to finalize a settlement agreement, which it could, the order from Chancellor Lyle could come down in that time period. So just make sure for full disclosure for the commission as y'all deliberate.
Our firms are kind of competitive with each other. I've never been able to do an appeal for $10,000. I mean, if it costs $10,000 to do an appeal, I'd be very surprised. I mean, it's more $40,000, $50,000, $60,000, $70,000 before you can complete an appeal of a case at our hourly rates. It's expensive. There's a lot of process. There's a thick book of the rules you have to follow. You have to cite, you have to cite to the record for every time you make a factual statement. It's a painstaking work. It's not to say that for good government's going to appeal, but if they do, there's going to be substantial expense.
Just to clarify again, Mr. Chairman, I want to make sure I don't want to be quoted as saying I thought it would just take 10. It could be into the tens, to be a full-blown appeal could be into the tens.
So between 10 and 20, or is it between 10 and 50?
I can't say standing here now, because if it's just one issue, if they don't contest it, there are different variables that could affect the amount, and at any time the election
Right.
commission could determine to
And-
drop the issue. So it's difficult to say.
And whether a 1983 action is appropriate in this case, isn't that a cutting-edge issue, first impression in Tennessee? So there's never been a reported decision in Tennessee on that issue. So there would be research done on what other states have done throughout the country.
We've had to brief that issue for a supplemental briefing required by Chancellor Lyle. It is not a simple issue. We've done some research into it already. But again, I mean, the cost of appeals just depend on how hard both sides want to fight it, and I can't put an exact number on it.
Okay. All right. Okay.
I'd like to call a question.
Okay. Is there any further discussion? Okay, we have a motion. It was your motion.
It's my
right?
motion, that
Okay.
we take option 2.
All right. Okay. All right. All in favor, say aye.
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 All opposed?
Nay.
Nay. The motion does not carry. Commissioners Davis, Evans, and Delanis voting no, and Commissioners Hertzfeld and Starling voting yes. Do we have another motion or further discussion?
Make a motion to, I guess, settle the $6,000.
Just settle it with, and as long as we get a full release?
Yeah.
Okay. Do we have a second?
I'll second.
Okay, we have a motion and a second. Any further discussion? Yes, sir.
Now, there is cost associated with the settlement.
Yeah.
Just want to get that on the record. There is a cost
Right.
to that.
Yeah,
Okay.
he'd have to prepare a release. And
Okay.
yes. Okay. All right, we have a motion and we have a second. All in favor, say aye.
Aye.
Any opposed? Okay. So we have Commissioners Hertzfeld, Davis, Evans, and Delanis voting yes, and Commissioner Starling voting no. Okay. Okay. All righty, let's see.
Thank you, Mr. Chair.
Thank
I
you,
will
appreciate it.
report back with a settlement agreement for
All righty.
the commission
Thank you,
to
sir.
consider.
Okay.
Thank you.
All right, I believe we are to the public comment period, and I believe we have at least one person who signed up. Betty Lynn. Yes, ma'am. I'm sorry I can't read your writing on your last name, but thank you for signing up, and we're happy to have you. Julie, I'm sorry. Gotcha. Okay. Yes, ma'am.
214
Yes,
in
ma'am.
Davidson County. The first thing I wanted to say was a thank you to the members of the Election Commission. This is really time-consuming for you all, I realize, and I just appreciate your dedication to that. I am grateful to Chairman Delanis, especially for his adeptness in maintaining meeting decorum. That is, I guess, a gift of yours. And to Mr. Starling for his recognition the other 2 or 3 meetings ago, I suppose it was, when you recognized and spoke to needing to be accountable in spending taxpayer dollars. However, in this case, I think what's happening is that the taxpayers are trying to be accountable for the spending of their own dollars, and they just want their voices to be heard in that respect. Similar sort of to what, as I was thinking last night, to what happened in 2018 with the transit bill. And I would say, too, if we could get through 2018, as I remember 2018, we can probably get through this without too much trouble, right, Joan? How many times did we vote that year? So then I think the last thing that I wanted to say, or it was also I appreciate the professor, his resolution that he wrote. It was something that I was capable of understanding even, so that was nice. I've been a homeowner in Davidson County for many, many years, and I am going on my 14th year, I believe, as a poll worker. And I just want to say the reason I do that is because I really believe that what the amendments say, Amendment 15, Amendment 19, that the right of the citizens of the United States to vote should not be denied or abridged in any way for any reason, not due to race or color or sex, and not due to the whims or wishes of a political party or politicians or bureaucrats. And I think it can be, the voting rights of citizens can be abridged and denied in any of those instances. So I would encourage you just to try to, and I know you do, try to keep those things in mind as you're making the decisions that you make, that the vote, many of us, and I am speaking actually for more than just myself, many of us recognize that our right to vote is one of the most precious rights we have as Americans. It's how we have a say. It's how our voice is heard. And there was a line in the last whereas of the resolution that the professor prepared that I just wanted to bring up. He says it is the Election Commission desires to preserve the ability to effectuate the intent of the voters. And I hope and pray that that is true. And I think with Jeff's leadership and everything, we can easily get through a voting date, even if it's coming down to the deadline to do so. We've done it before, and I know we can do it again. So
Thank you.
Just a thank you to everyone for your time.
Thank you. Okay. I think we're almost to the time of adjournment, but we need to set a date and time of the next meeting if we know that. But while I have the microphone here, let me apologize and point out that when I handed out the memo from the open records people, I don't have the second page of it. There is an answer to that question number 5, and it's in our packets. We do have that page number 2 in our packets. So if you could look at that page number 2 for the answer to that last question. Mr. Roberts, do you have a recommendation for a time and date for our next meeting?
You know, at this point, Mr. Chairman, I think it needs to be the call of the chair.
Does anybody on the commission want to? Is that satisfactory with everybody on the commission? Okay. All right. With that, I think we've come to our favorite part of the meeting, which is item 12, to adjourn. We have a motion. Second. We have a motion and a second. All in favor say aye. Aye. With no opposition, the motion carries. Thank you all. We appreciate your being here.
Again, or for more information about this and other programs, visit nashville.gov.